Section 7. Text of Section 7. Senatorial Apportionment Commission Number, Appointment, Duties, Compensation. A. Within 60 days after the population of this state is reported to the President for each decennial census of the United States, and/or within 60 days after that a redistricting plan has been invalidated by a court of competent jurisdiction, the State Committee and the Congressional District Committees of each of the two political parties casting the highest vote for governor at the last preceding general election shall meet, and the members of each committee shall nominate, by a majority vote of the elected members of the committee present, provided that a majority of the elected members is present, members of their party, residents in that district, in the case of a Congressional District Committee, as nominees for the Senate Independent Bipartisan Citizens Commission. No party shall select more than one nominee from any one state legislative district. The Congressional District Committees shall each submit to the governor their list of 2 elected nominees. The state committees shall each submit to the governor their list of 5 elected nominees. Within 30 days thereafter the governor shall appoint a Senate Independent Bipartisan Citizens Commission consisting of 2 nominees from each list submitted by each state committee and 1 nominee from each list submitted by each Congressional District Committee, to redistrict the 34 senatorial districts and to establish the numbers and boundaries of said districts. No person shall be appointed to both the House Independent Bipartisan Citizens Commission and the Senate Independent Bipartisan Citizens Commission during the same redistricting cycle. If any committee fails to submit a list within such time, the governor shall appoint a member of his or her own choice from the political party of the committee failing to submit a list, provided that in the case of a Congressional District Committee failing to submit a list, the person appointed to the commission by the governor shall reside in the congressional district of such committee. Members of the commission shall be disqualified from holding office as members of the General Assembly for 4 years following the date of the filing by the commission of its final redistricting plan. B. The commissioners so selected shall on the 15th day, excluding Sundays and state holidays, after all members have been appointed, meet in the Capitol building and proceed to organize by electing from their number a chairman, vice chairman, and secretary. The Commission shall adopt an agenda establishing at least 3 hearing dates on which hearings open to the public shall be held to hear objections or testimony from interested persons. A copy of the agenda shall be filed with the Secretary of the Senate within 24 hours after its adoption. Executive meetings may be scheduled and held as often as the Commission deems advisable. C. The Senate Independent Bipartisan Citizens Commission shall redistrict the Senate using the same methods and criteria as those required by subsection B, Section 3 of this article for the redistricting of the House of Representatives. D. Not later than 5 months after the appointment of the Senate Independent Bipartisan Citizens Commission, the Commission shall file with the Secretary of State a tentative redistricting plan and map of the proposed districts, and during the ensuing 15 days shall hold such public hearings as may be necessary to hear objections or testimony of interested persons. The Commission shall make public the tentative redistricting plan and map of the proposed districts, as well as all demographic and partisan data used in the creation of the plan and map. E. Not later than 6 months after the appointment of the Commission, the Commission shall file with the Secretary of State a final statement of the numbers and the boundaries of the districts together with a map of the districts, and no statement shall be valid unless approved by at least 7/10 of the members. F. After the final statement is filed, senators shall be elected according to such districts until a new redistricting plan is made as provided in this section, except that if the final statement is not filed within 6 months of the time fixed for the appointment of the Commission, the Commission shall stand discharged and the Senate shall be redistricted using the same methods and criteria as described in subsection B of Section 3 of this article by a commission of 6 members appointed from among the judges of the appellate courts of the state of Missouri by the state Supreme Court, a majority of whom shall sign and file its redistricting plan and map with the Secretary of State within 90 days of the date of the discharge of the Senate Independent Bipartisan Citizens Commission. The Judicial Commission shall make public the tentative redistricting plan and map of the proposed districts, as well as all demographic and partisan data used in the creation of the plan and map. Thereafter, senators shall be elected according to such districts until a redistricting plan is made as provided in this section. G. Each member of the Commission shall receive as compensation $15 a day for each day the Commission is in session, but not more than $1,000, and, in addition, shall be reimbursed for his or her actual and necessary expenses incurred while serving as a member of the Commission. H. No redistricting plan shall be subject to the referendum. I. Any action expressly or implicitly alleging that a redistricting plan violates this Constitution, federal law, or the United States Constitution shall be filed in the Circuit Court of Cole County and shall name the body that approved the challenged redistricting plan as a defendant. Only an eligible Missouri voter who sustains an individual injury by virtue of residing in a district that exhibits the alleged violation, and whose injury is remedied by a differently drawn district, shall have standing. If the court renders a judgment in which it finds that a completed redistricting plan exhibits the alleged violation, its judgment shall adjust only those districts, and only those parts of district boundaries, necessary to bring the map into compliance. The Supreme Court shall have exclusive appellate jurisdiction upon the filing of a notice of appeal within 10 days after the judgment has become final. 1. Amendments. Amended January 14, 1966. Amended with the approval of Missouri Measure 12, 1982, on November 2, 1982. Amended with the approval of Missouri Amendment 1, Lobbying, Campaign Finance, and Redistricting Initiative, 2018, on November 6, 2018. Amended with the approval of Amendment 3 on November 3, 2020. Section 8. Text of Section 8. Term limitations for members of General Assembly. No one shall be elected to serve more than 8 years total in any one house of the General Assembly nor more than 16 years total in both houses of the General Assembly. In applying this section, service in the General Assembly resulting from an election prior to December 3, 1992, or service of less than 1 year, in the case of a member of the House of Representatives, or 2 years, in the case of a member of the Senate, by a person elected after the effective date of this section to complete the term of another person, shall not be counted. 1. Amendments. Adopted with the approval of Missouri State Legislative Term Limits, Amendment 12, 1992, on November 3, 1992. Amended with the approval of Missouri Term Limit Calculations, Amendment 3, 2002, on November 5, 2002. Section 9. Text of Section 9. Apportionment of Representatives. Until the convening of the 74th General Assembly, the House of Representatives shall consist of 163 members elected from the 163 representative districts, as they existed January 1, 1965. 1. Amendments. Amended January 14, 1966. Section 10. Text of Section 10. Basis of apportionment: alteration of districts. The last decennial census of the United States shall be used in apportioning representatives and determining the population of senatorial and representative districts. Such districts may be altered from time to time as public convenience may require. 1. Section 11. Text of Section 11. Time of election of senators and representatives. The first election of senators and representatives under this Constitution shall be held at the general election in the year 1946, when the whole number of representatives and the senators from the districts having even numbers, who shall compose the first class, shall be elected, and 2 years thereafter the whole number of representatives and the senators from districts having odd numbers, who shall compose the second class, shall be elected, and so on at each succeeding general election. 1. Section 12. Text of Section 12. Members of General Assembly disqualified from holding other offices. No person holding any lucrative office or employment under the United States, this state, or any municipality thereof shall hold the office of senator or representative. When any senator or representative accepts any office or employment under the United States, this state, or any municipality thereof, his office shall thereby be vacated and he shall thereafter perform no duty and receive no salary as senator or representative. During the term for which he was elected, no senator or representative shall accept any appointive office or employment under this state which is created or the emoluments of which are increased during such term. This section shall not apply to members of the organized militia, of the Reserve Corps and of school boards, and notaries public. 1. Section 13. Text of Section 13. Vacations of office by removal of residence. If any senator or representative remove his residence from the district or county for which he was elected, his office shall thereby be vacated. 1. Section 14. Text of Section 14. Writs of election to fill vacancies. Writs of election to fill vacancies in either house of the General Assembly shall be issued by the Governor. 1. Section 15. Text of Section 15. Oath of office of members of Assembly administration, effect of refusal to take oath and conviction of violation. Every senator or representative elect, before entering upon the duties of his office, shall take and subscribe the following oath or affirmation: I do solemnly swear, or affirm, that I will support the Constitution of the United States and of the State of Missouri, and faithfully perform the duties of my office, and that I will not knowingly receive, directly or indirectly, any money or other valuable thing for the performance or non-performance of any act or duty pertaining to my office, other than the compensation allowed by law. The oath shall be administered in the halls of the respective houses to the members thereof, by a judge of the Supreme Court or a circuit court, or after the organization by the presiding officer of either house, and shall be filed in the office of the Secretary of State. Any senator or representative refusing to take said oath or affirmation shall be deemed to have vacated his office, and any member convicted of having violated his oath or affirmation shall be deemed guilty of perjury, and be forever disqualified from holding any office of trust or profit in this state. 1. Section 16. Text of Section 16. Compensation, mileage allowance, and expenses of General Assembly members. Senators and representatives shall receive from the state treasury as salary such sums as are provided by law. No law fixing the compensation of members of the General Assembly shall become effective until the first day of the regular session of the General Assembly next following the session at which the law was enacted. Upon certification by the President and Secretary of the Senate and by the Speaker and Chief Clerk of the House of Representatives as to the respective members thereof, the State Controller shall audit and the State Treasurer shall pay such compensation without legislative enactment. Until otherwise provided by law, senators and representatives shall receive $1 for every 10 miles traveled in going to and returning from their place of meeting while the legislature is in session, on the most usual route. Until otherwise provided by law, each senator or representative shall be reimbursed from the state treasury for the actual and necessary expenses incurred by him in attending sessions of the General Assembly in the sum of $10 per day for each day on which the Journal of the Senate or House respectively shows the presence of such senator or representative. Upon certification by the President and Secretary of the Senate and by the Speaker and Chief Clerk of the House of Representatives as to the respective members thereof, the State Controller shall approve and the State Treasurer shall pay monthly such expense allowance without legislative enactment. 1. Amendments. Amended on November 3, 1970. Section 17. Text of Section 17. Limitation on number of legislative employees. Until otherwise provided by law, the House of Representatives shall not employ more than 125 and the Senate shall not employ more than 75 employees elective, appointive, or any other at any time during any session. 1. Amendments. Adopted on November 8, 1932. Amended on November 3, 1970. Section 18. Text of Section 3. Appointment of officers of House's jurisdiction to determine membership power to make rules, punish for contempt and disorderly conduct and expel members. Each House shall appoint its own officers, shall be sole judge of the qualifications, election, and returns of its own members, may determine the rules of its own proceedings, except as herein provided, may arrest and punish by fine not exceeding $300, or imprisonment in a county jail not exceeding 10 days, or both, any person not a member, who shall be guilty of disrespect to the House by any disorderly or contemptuous behavior in its presence during its sessions, may punish its members for disorderly conduct, and, with the concurrence of 2/3 of all members elect, may expel a member, but no member shall be expelled a second time for the same cause. 1. Section 19. Text of Section 19. Legislative privileges. A. Senators and representatives shall, in all cases except treason, felony, offenses under this article, or breach of the peace, be privileged from arrest during the session of the General Assembly, and for the 15 days next before the commencement and after the termination of each session, and they shall not be questioned for any speech or debate in either House in any other place. B. Legislative records shall be public records and subject to generally applicable state laws governing public access to public records, including the Sunshine Law. Legislative records include, but are not limited to all records, in whatever form or format, of the official acts of the General Assembly, of the official acts of legislative committees, of the official acts of members of the General Assembly, of individual legislators, their employees and staff, of the conduct of legislative business and all records that are created, stored, or distributed through legislative branch facilities, equipment or mechanisms, including electronic. Each member of the General Assembly is the custodian of legislative records under the custody and control of the member, their employees, and staff. The Chief Clerk of the House or the Secretary of the Senate 8 the custodians for all other legislative records relating to the House and the Senate, respectively. C. Legislative proceedings, including committee shall be public meetings subject to generally applicable law governing public access to public meetings, including the Sunshine Law. Open public meetings of legislative proceedings shall be subject to recording by citizens, so long as the proceedings are not materially disrupted. 1. Amendments. Amended with the approval of Missouri Amendment 1, Lobbying, Campaign Finance, and Redistricting Initiative, 2018, on November 6, 2018. Section 20. Text of Section 20. Regular sessions of Assembly quorum compulsory attendance public sessions limitation on power to adjourn. The General Assembly shall meet on the first Wednesday after the first Monday in January following each general election. The General Assembly may provide by law for the introduction of bills during the period between the first day of December and the first Wednesday after the first Monday of January. The General Assembly shall reconvene on the first Wednesday after the first Monday of January after adjournment at midnight on May 30 of the preceding year. A majority of the elected members of each House shall constitute a quorum to do business, but a smaller number may adjourn from day to day, and may compel the attendance of absent members in such manner and under such penalties as each House may provide. The sessions of each House shall be held with open doors, except in cases which may require secrecy but not including the final vote on bills, resolutions, and confirmations. Neither House shall, without the consent of the other, adjourn for more than 10 days at any one time, nor to any other place than that in which the two houses may be sitting. 1. Amendments. Amended on November 3, 1970. Amended with the approval of Missouri Issue 1, General, 1988, on November 8, 1988. Section 20, A. Text of Section 20, A. Automatic adjournment tabling of bills, when the General Assembly shall adjourn at midnight on May 30 until the first Wednesday after the first Monday of January of the following year, unless it has adjourned prior thereto. All bills in either house remaining on the calendar after 6 o'clock p.m. on the first Friday following the second Monday in May are tabled. The period between the first Friday following the second Monday in May and May 30th shall be devoted to the enrolling, engrossing, and the signing in open session by officers of the respective houses of bills passed prior to 6 o'clock p.m. on the first Friday following the second Monday in May. The General Assembly shall automatically stand adjourned sine die at 6 o'clock p.m. on the 60th calendar day after the date of its convening in special session unless it has adjourned sine die prior thereto. 1. Amendments. Adopted on November 4, 1952. Amended on November 8, 1960. Amended on November 3, 1970. Amended with the approval of Missouri Issue 1, General, 1988, on November 8, 1988. Section 20, B. Text of Section 20, B. Special Session, Procedure to Convene Limitations Automatic Adjournment. Upon the filing with the Secretary of State of a petition stating the purpose for which the session is to be called and signed by 3/4 of the members of the Senate and 3/4 of the members of the House of Representatives, the President pro tem of the Senate and the Speaker of the House shall by joint proclamation convene the General Assembly in special session. The proclamation shall state specifically each matter contained in the petition on which action is deemed necessary. No appropriation bill shall be considered in a special session convened pursuant to this section if in that year the General Assembly has not passed the operating budget in compliance with Section 25 of this article. The General Assembly shall automatically stand adjourned sine die at 6 o'clock p.m. on the 30th calendar day after the date of its convening in special session under this section unless it has adjourned sine die prior thereto. 1. Amendments. Amended with the approval of Missouri Issue 1, General, 1988, on November 8, 1988. Section 20, C. Text of Section 20, C. No political fundraising activities or political fundraising event by any member of or candidate for the General Assembly, including but not limited to the solicitation or delivery of contributions, supporting or opposing any candidate, initiative petition, referendum petition, ballot measure, political party, or political committee, shall occur in or on any premises, property, or building owned, leased or controlled by the state of Missouri or any agency or division thereof. Any purposeful violation of this section shall be punishable by imprisonment for up to 1 year or a fine of up to $1,000 or both, plus an amount equal to 3 times the illegal contributions. The Missouri Ethics Commission or its successor agency is authorized to enforce this section as provided by law. 1. Amendments. Added with the approval of Missouri Amendment 1, Lobbying, Campaign Finance, and Redistricting Initiative, 2018, on November 6, 2018. Section 20, D. Text of Section 20, D. If any provision of Sections 2, 3, 7, 19, or 20, c, or the application thereof to anyone or to any circumstance is held invalid, the remainder of those provisions and the application of such provisions to other or other circumstances shall not be affected thereby. 1. Amendments. Added with the approval of Missouri Amendment 1, Lobbying, Campaign Finance, and Redistricting Initiative, 2018, on November 6, 2018. Legislative Proceedings. Section 21. Text of Section 21. Style of Laws Bills Limitation on Amendments Power of each House to originate and amend bills Reading of bills. Style of Laws Bills Limitation on Amendments Power of each House to originate and amend bills Reading of bills. The style of the laws of this state shall be it enacted by the General Assembly of the State of Missouri, as follows. No law shall be passed except by bill, and no bill shall be so amended in its passage through either house as to change its original purpose. Bills may originate in either house and may be amended or rejected by the other. Every bill shall be read by title on 3 different days in each house. 1. Section 22. Text of Section 22. Referral of bills to committees. Recall of referred bills. Records of committees. Provision for interim meetings. Every bill shall be referred to a committee of the House in which it is pending. After it has been referred to a committee, 1/3 of the elected members of the respective houses shall have power to relieve a committee of further consideration of a bill and place it on the calendar for consideration. Each committee shall keep such record of its proceedings as is required by rule of the respective houses, and this record and the recorded vote of the members of the committee shall be filed with all reports on bills. Each House of the General Assembly may provide by rule for such committees of that House as it deems necessary to meet to consider bills or to perform any other necessary legislative function during the interim between the session ending on the 30th day of May and the session commencing on the first Wednesday after the first Monday of January. 1. Amendments. Amended on November 3, 1970. Amended with the approval of Missouri Issue 1, General, 1988, on November 8, 1988. Section 23. Text of Section 23. Limitation of scope of bills. Contents of titles. Exceptions. No bill shall contain more than one subject which shall be clearly expressed in its title, except bills enacted under the third exception in Section 37 of this article and general appropriation bills, which may embrace the various subjects and accounts for which monies are appropriated. 1.